Well, hi there. Warm welcome. You're watching Blueprint Explosive Exclusive with me, Meghna Deka. Now, viewers, in what appears to be a very significant development and a big setback for the centre, the Bombay High Court today has struck down the amendments to the information technology rules which sought to identify fake and false content on social media against the government. Essentially, the story is that the fact-check units, which were supposed to be looking at all the social media content which was posted specifically against the government, would have had sweeping powers to get them removed. Now, this is something which first was put on hold by the Supreme Court, and then it went to a court, and there was a split judgment. Following that, there was a tiebreaker judgment today, and this is the one which has struck down in the Bombay High Court, which struck down the amendments to these IT rules, and essentially the fact-check units which the government was looking to set up as unconstitutional. Yes, that's right. That's what the Bombay High Court has said. In fact, under the IT rules, if the fact-check units come across any posts that are fake, false and may contain misleading facts about the business of the government, it would flag the same to social media intermediaries. Now, this had been struck down by the High Court today. Now, remember, petitions were filed before the Bombay High Court, which delivered a split verdict on the petitions challenging the amended IT rules. This matter, as I was telling you earlier, was then assigned to Justice A.S. Chandurkar as the tiebreaker judge. In the previous hearing, Justice Patel had struck down the rules while Justice Gokhale had upheld them. So let's tell you more in detail about what the Bombay High Court had said in its order today. For that, let me take you across to the big screen and where we are putting out the details of the order which has come in. It said, the first observation, that the impugned rules are violative of Article 14, which is the right to equality. Of course, comes in the backdrop of the order which came in the Supreme Court way back in March. The Supreme Court had stayed the operation of the fact-check unit, which was notified yesterday under the IT rules of 2021 by the Ministry of Electronics and Information Technology. In fact, the Apex Court had also stayed all of this. This is what Justice A.S. Chandurkar has said of the Bombay High Court, which was the tiebreaker observation which led to the scrapping of the new IT rules. He also went on to say, expressions of false, fake and misleading are vague. It is very vague. It's quantitative, it's qualitative rather than quantitative, and who really gets to decide? It's very vague and ambiguous. Also, he has said that hence they are wrong in absence of any specific definition of what really is violative, because all of this could be very, very subjective in nature. He's also said, hence, they are wrong in the absence of any specific definition. So remember, this comes on the backdrop, as I was telling you, of the Supreme Court way back in March. The Supreme Court had stayed these fact-check units, and yesterday this unit was actually notified. The Apex Court had stayed the notification till the Bombay High Court decides the challenges to the Information Technology Rules Amendment of 2023. Let's also tell you what exactly it is that the Supreme Court had said. These are the observations, that issues deal with the core values of freedom of speech. It went on to say that the centre should have waited for the final Bombay High Court verdict instead of notifying the rules, and let the issue be adjudicated and decided by the Bombay High Court. This is what the court had said then. The court had also said that the centre had assured the High Court that it will wait for the final verdict. The status quo cannot be altered at this stage. This is what the Supreme Court had said when it decided to put this on hold. So let me go across to our panelists. Joining us today on the show, we have Advocate Virag Gupta, a cyber law expert, as well as Sanjay Hegde, a senior advocate. Sanjay Hegde, I'm going to come to you first. It's very interesting what exactly the words of Justice Atul Chandurkar was, and I'm going to quote him yet again. I'm of the opinion that the amendments are violative of Article 14 and Article 19 of the Constitution of India. Would you see this as a big win for freedom of expression?
Absolutely so, because what the rules basically said was that, look, there will be a government fact-checking unit that will certify what is the correct fact, and especially with regard to anything that the government puts out. Thereafter, if there was any content which was not in accordance with what the official government statement of fact was, then intermediaries like Meta, or that's Facebook and Insta, or Twitter, X, etc., would possibly have to either flag that content as being untrue, or to bring it down altogether. So essentially, what the government was trying to do through the rules was to establish a government body, which, in George Orwell's words, could very well be called the Ministry of Truth. This is the truth, and if there is anything which is against which is violative of this truth, this one truth, then it would have to be flagged by the site, or it will have to be taken down. That is an unrestricted, that's an unreasonable restriction on the freedom of speech and expression.
Okay.
And as Justice Chandulkar has said, those words as to what is untrue and all that are very, very widely worded.
There is ambiguity about those words.
Just to give you you and your viewers an idea of the question. So, does veg biryani exist? Now, if the government Ministry of Truth were to say yes, veg biryani exists, can anybody say no, it does not exist? Should there only be the government's version? That it just cannot be.
Well, thank you so much, Sanjay Hegde, for contextualizing the High Court order. But yes, in fact, let me take that across to Virag Gupta. Because one of the problems, and this is something that Sanjay Hegde, as well as most of the petitioners, had the problem, that it was very broad, it was vague, it was discriminatory, and hence it was discriminatory and arbitrary as well, because it was also focusing on specific online content pertaining to the government. That's the easiest, the petitioners say, to try and clamp down on any news, any article, any reel, any photograph, which the government may be sensitive towards.
Meghna, I appreciate and welcome this judgment. But there are more than what is discussed in this judgment, and Mr. Hegde knows it very well, because private players like the Twitter or the Meta are doing a lot of censor activities. They are blocking they are banning the accounts, they are blocking the content, they are censoring the content. So I think that government in this whole digital regime has a very little role. I will say only 1%, and 99% roles is played by the tech giants. Now the issue is that in India, we are only on these fake narratives. This is only academic something, litigation going on. And the real litigation is going on European Union and the USA, where they are saying that how these Meta, Facebook, or those companies who are taking all advantage of the intermediary, but playing the big role. And when they are doing everything, they are sharing our data, they are violating the privacy, then we don't have any objection. But once a government, which is a duly elected government and the sovereign body, and when something is being done, so we are, I think...
But Virag Gupta, does it matter who tries to censor the content which is going out? Who is trying to stifle freedom of speech, whether it's one of these big conglomerates that you've spoken about, global ones, or the government? Why should anyone do it?
No, let us understand the three aspects which are missing from this current debate.
Okay.
The first is freedom of expression is a fundamental right, and that is our constitutional right, and that must be protected by the government as well as the private players. Now, first, India, we don't have the data protection law. So our data is violated and rules are not notified, and nobody is fighting for that. That is the first problem. Second thing is, artificial intelligence is being used for generation of large content of these fake and other narratives, and nothing is being done in India. That is the second problem. Now, the third problem is that all the political parties are running their own IT cells, and IT cells are the biggest source of this fake narrative factory, and nothing is being done. So what I'm saying that to our protect the constitutional rights guaranteed under Article 14 and 19, so bigger right is Article 21, that is right to life. And that right to life has to be protected by controlling this fake content, which is very viral in the social media. And nothing is being done neither by the judiciary nor by the government.
Is that what's happening, Sanjay Hegde? Some of the bigger problems have not been addressed. But let's not forget the government did rush in to notify this amendment to the IT, even though they had told the Supreme Court that we'd wait.
Well, it's obvious that they chose to rush in closer to election time. They had a kind of free, the ruling party at the center had a kind of free run in the early stages of the information explosion, which came along with the increase in mobile internet. But as more and more players came in, as more and more news started getting disseminated, that is when the government says, "Oh, we need to at least have some control." And therefore, our idea, the bureaucratic idea, is that we shall establish one unit within MeitY or the Information Ministry to say that this is the correct version, and that's all right. You are entitled to put out your version of the things and say that. But you cannot then say that no other version will be allowed to survive, or without a disclaimer, or by bringing it down. And I do agree with Mr. Garg that we lack a privacy law. But you had a majority government for most of the time, past decade. The privacy law was the least of your concerns. You had the Justice Sri Krishna Commission making recommendations, but then everybody soft-pedaled it. So there are many problems.
This is just one of them. Data privacy is something I think all of us would agree on. But Sanjay Hegde, let's not forget, and I'm just going to, I'm going to quote Justice Gokhale here. This is during the split verdict which was given way back in Jan. She had said there, she had held there, it is not unconstitutional, the amendments which have been made to the IT law, because the allegations of possible bias raised by the petitioners were completely unfounded, that there was no restriction in free speech, nor do the amendments suggest that there were any penal consequences for any users. So how is this a clampdown? Sanjay Hegde, those who are backing these amendments have asked.
Well, Justice Gokhale possibly forgets that the content itself could be taken down. Now, if you have an access to the public square, but you are free to speak only as long as your speech agrees with that of the government, saying this is the government version, and I agree with it.
Is that what it is?
You are entitled to speak.
A quick word from Virag Gupta. Is that what it is? All of this was also timed to the elections, Sanjay Hegde has alleged, to give the then government in power a free run.
I fully agree that during election period, there is a government effort to control the social media, and many times when the parliamentary committees are working for the government, I fully agree. But broader issue are three issues. Number one, in this judgment, I'm something surprised that how the two judges, when they differ, a third judge can define. This tiebreaker, judicially, I don't appreciate this thing, because it should go to the larger bench of three judges. That is my first objection. Now, the second problem is, government cannot do the fact check, but government has power to block that whole intermediary. So you have a very big power. You can give a death penalty, but you cannot beat. So that is the second thing. Now the third problem is, this whole fake news is a big financial business. Now for this financial business, we don't have clear-cut laws relating to the safe harbor. We don't have. Now, secondly, we don't have, biggest issue is law and order comes within the scope of the state government as per the 7th schedule of the constitution. But here, government is doing everything, central government, and state government, so that federal aspect is missing in this whole debate.
Oh, that's also very interesting. What role should the states play when it comes to censorship? But also, again, it brings us back to the fundamental question. Who decides what is acceptable, what is fake, and what is not? Because it is not yet quantifiable. A lot of it is subjective and hence vague. At least that exactly is what the tiebreaker verdict today has held. We leave it there, gentlemen. Thank you so much, Advocate Virag Gupta, as well as Sanjay Hegde, for joining us, sharing your perspective on it. Of course, this Bombay High Court ruling has is going to go a long way when it comes to setting a precedent. And of course, the need for cybersecurity and laws which are looking into specifics of data safety is still absent. I think we all agree on that. Without a short break, don't go anywhere.